welcome once again to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and at times your business. We continue to provide information and resources that will help you decide whether you need to contact a lawyer. You may be able to handle some issues yourself. Our goal, of course, is for you to achieve the best possible results while saving time, money, and, of course, resources. We once again want to welcome and thank Attorney David Bazar from the Bazar and Associates Law Firm in East Providence, who continues to weigh in on the various topics that we address. And today, slip and fall injuries. We've discussed this before. The 5 most common types of personal injury claims apparently are vehicles, we've spoken of those, medical malpractice, the slip and fall, boating, and wrongful death. So we're going to focus on slip and falls today, and there are some very interesting, kind of terrible, facts that are reported by the World Health Organization. Here goes. Falls are the second leading cause of unintentional injury deaths worldwide. Each year, an estimated 684,000 individuals die from falls globally. Adults over 60 years of age, suffer the greatest number of fatal falls, and 37.3 million falls that are severe enough are requiring medical attention, and it happens every year. And also, there are 37.3 that says that they're requiring medical attention and are also likely to cause lawsuits. So, while these are major health problems, we know they can happen anywhere from personal residences to retail stores to parking lots, etc. So, how do you know whether or not you have a serious case? How do you know if it's worthy of a suit? What should you do? How quickly should you do it? How do you avoid the pitfalls that you're likely to cross? And when should you reach out? What's that whole process like? So, David, let's go through that. Obviously, those are some rather serious numbers, and I guess they don't lessen every year. They seem to increase. Let's go through what that part of personal injury is about.
So the first question I heard you raise is, when do I need to contact someone? When do I know if I have a case or not? When is it serious? So most of personal injury cases, whether they're serious or not, depend on the injury or damages, because the liability we can always look at and determine whether or not there is any liability. But if you fell and you weren't hurt, then there really is no need to contact an attorney because there's been no injury. So the real issue in determining the seriousness of whether or not you have a claim is the seriousness of the injury. So if you've fallen and you've broken a bone or hurt yourself to the extent where you can't do your normal work or your daily activities of living, then you probably have a situation that in the first instance you ought to be thinking about contacting an attorney.
So while I was reading this, and we have covered this in previous episodes over a number of years, it seems that there actually could be many occasions when you don't really realize the severity of it. So it might be readily apparent if you've broken a bone, or even if you have what they call a soft tissue injury, it might not be outwardly visible, but you could have some damage that lingers and impairs your productivity, your ability to work or whatever. So I think how many times people might stumble off of a curbstone or maybe slip in a grocery store. We'll get into those, but they might brush themselves off and say quickly, no problem, no harm, no foul, and keep moving. And I guess this was sort of alarming because not always is the true extent of an injury apparent. So if something like that falls, what do you advise? Should someone immediately get to a doctor or not a hospital, emergency care or something? Do you think that that's necessary?
It depends how you feel. So obviously if you broke a bone, you're going to feel that and you're going to do something about that. If you twisted an ankle, tore some cartilage or ligament in your knee or your shoulder or your back, you might have so much adrenaline at the time going
Exactly.
through your system that you might not realize the extent of your injury. But when that wears off, you'll start to feel it and you'll know. So usually within the first 24 hours, you're going to know whether or not you've been injured to the extent that you need medical treatment. And if you've been injured to the extent that you do need medical treatment, that's when you need to call a lawyer.
So we always say go have it checked as soon as possible. 24 hours is still considered to be reasonable?
Yeah, I mean, if you get beyond that, it's, is there really anything going on, or is it so minor that you don't need it checked? But I'm just choosing some time frame to say that eventually the adrenaline that is going to be masking some of the pain is going to go away. And when you start feeling the pain and not, having something that you hadn't had before, that's when you need to see someone.
If you hit your head, you might have had a goose egg, or you might have had a slight headache. It's nothing. Ice it, take an aspirin and go home. And yet, you know that depending on the severity, as you point out, someone might actually have a brain injury of some sort. You don't really know. You would think you might know, but some of these things don't show up as a concussion until you have it checked out later.
Yeah, head injury can be very serious and something you have to be really careful about. So if you hit your head, I would go to the hospital to make sure that I don't have a subdural hematoma or some kind of injury that I might not know about right away. You might have a headache, but it's slight, whatever. If you did hit your head, then you really got to be careful with that.
So someone has had a minor injury, or it's what seems to be a minor injury. They go to the doctor, they go to a hospital or an urgent care center, and they find out that it's a little more than what they had expected. Maybe it's a lot more. Mm-hmm. How soon, we always say, yes, as soon as possible, but how soon should they actually reach out and say, maybe there's a problem here, and contact someone like you because maybe it was someone else's fault, premises liability, negligence, or whatever?
With slip and fall injuries in particular, the sooner you reach out to the attorney, the better, because unlike auto accidents where there's usually a police report, and if there are witnesses, perhaps witness statements, you got to try to get to an attorney to try to preserve as much of the scene as to where this happened as possible. Oftentimes, if it's in a retail store or outside of one, there might be cameras where you might be able to get some film or footage of what happened. And if you reached out to an attorney, they can send a letter or contact the folks right away and say, preserve that evidence, because not all places keep every day forever. They tape over it or they don't keep it for whatever reason. So you want to make sure you do whatever you can to preserve any evidence of what caused the slip and fall.
So let's go through, what is that process? If I call you because there's been some sort of an injury, I might not be able to make a visit to your office. Maybe I'm in the hospital, maybe I'm just not able to go. What happens, what's the procedure, and how soon do you start doing whatever you do? Could you go through that a little bit?
Yeah, so if you're in the hospital or you're injured at home and you can't get out, I still would call the attorney and ask, if this is the type of case you handle, and let them get started on the process for you. Again, it's preserving evidence in a slip and fall that can be very important. So, for example, if a client fell in a theater, and you wanted to get in and see where it was that they fell, and you want to contact them and try to preserve that evidence, you want to be able to get in and do that as quickly as possible before things change. And if it was, in a grocery store and there was a slip and fall, usually the grocery store, when you fall, will come and take an incident report and gather some information. And you want to make sure as the attorney that whatever information they've gathered, they're going to say that it's probably gathered in preparation or anticipation of litigation, so they might not share it, but you want to make sure they preserve it in case there's a reason for you to be able to get it. So there are all sorts of things that an attorney can do, photographs, pictures of the scene. If you slipped and fell on snow and ice, which who knows if we're going to have that again. It's pretty warm today.
Yes.
But if it's snow and ice, you might want to get someone out to the scene to film or photograph what it looks like and what it was like when you fell, or the attorney will do that if you contact them. These are important steps to take.
So you might actually dispatch several people to whatever has to happen, whether it's to go to that grocery store or to see if you can find witnesses. I know you've always said, if it's possible, whenever something happens, if you're in the position yourself as the victim, to photograph what you can, or video what you can, or take a picture or a name of someone who might have seen it, if they can. And of course, not always can that happen,
Right.
but that becomes your job the minute someone calls.
As soon as something happens, the sooner to that you start getting information, the more likely you are to be able to gather all the information you need. So if you fell and someone saw it, I know if you're hurt, it's not going to be what's on your mind, but if there's a way to get, hey, could you write your name and number down for me? Did you see what happened? And just get as many folks who might have witnessed it information, so that hopefully they'll be good Samaritans and give a statement or a deposition if it comes to that at some point down the road, so that they can say, yeah, we saw what happened and this is what happened. And certainly if you have those names and numbers of folks that saw it, the attorney might want to contact them and get something in writing from them or a statement as soon as they can, so that the closer to the incident that you start preserving information and evidence, the more you have reliable evidence. Someone's memory can fade if it takes too long to contact them, or they might not be willing to help at a certain point down the road.
Would you be doing these things when someone calls you if you haven't yet determined the extent of their injuries or how serious or long-lasting they're likely to be? Because not always, as we said, not always is it immediately known whether there are things that are going to linger here that are going to be costly. Obviously, you don't want to have someone have a frivolous case, but how do you determine, and when do you determine, and when do you not send out the troops to start gathering evidence?
If someone called and said, I fell, they didn't shovel, I wasn't hurt, I haven't gone to the hospital, it was 5 months ago, yeah, well, not anything we're going to be able to do to help you. But if someone calls and said, I fell and this is how I fell and I'm at the hospital, or I broke my leg, I'm home but I can't get out, then we'll pretty much know in that phone call that there's some serious injury or significant enough injury that would warrant us trying to get out as quickly as possible to start gathering information. So remember, there are several things that go into whether or not somebody else is liable for the damages that you suffered as a result of a slip and fall or that type of injury. And it's a negligence case. I think you referenced at the beginning there are several types of negligent cases: auto accidents, malpractice, wrongful death cases, boating accidents, I think you said.
Yes, there's one.
And slip and falls. And what goes into all of those is, in order to sue somebody to recover for your damages, that person has to be responsible for your damages, which means they were negligent. And in law school, you'll learn negligence has several components. One is which they owe a duty to you. And so if it's a slip and fall on snow and ice, did they owe a duty to remove the snow and ice or treat it? Did they have an opportunity to do that? And did they act in a way a reasonable person, if it's a store owner, would have acted under like circumstances? And if they didn't, then they breached that duty that they owed to you. So if they had a duty and they breached the duty, is there a proximate cause from that breach, this is law school stuff, to the injury that you suffered? Which means, if they had done what they were supposed to do, would you have still fallen and gotten hurt? And if not, then they're responsible for your injury. So in order to find out all the other things that go into the elements of what negligence is, a lawyer or whoever else is going to start gathering evidence needs to get out and start getting as much evidence and information to determine whether or not all of those elements are met for a negligence case.
In the middle there somewhere was, did they take care of whatever? So there's always a question, I guess, I'm not in it as you are, but what is reasonable? There are some things that certainly aren't. Is that often a gray area where you could debate how reasonable it would be for the grocery store to clean up the spill on aisle 4 versus the shop owner to put ice melt down if there's a storm? Is that a sliding scale? Or?
It is in some ways. So, for example, the grocery store with the spill on aisle 4. If somebody had walked through just before you and knocked something over, bottle of olive oil and that's on the floor and then you came right along and slipped and fell in it, what opportunity did the store owner have to go and clean that up before you fell? But if someone spilled it on the floor and it had been there for a while and there are foot tracks or footprints through it and you can tell this has been here for a while, they should have had time to clean it up, then obviously they didn't act reasonably and they would be liable. So that's just an example, and it's really an example of what is the notice that they had of the defect and what time, how timely were they in curing the defect. So we talked about snow a little bit. If it's snowing out and it's been snowing for a while and there are footprints back and forth in the snow and nothing has been done to treat the snow outside of the store that you're going into, then they probably are liable because they had time, they had notice of it, and you're an expected, foreseeable person to be on that property. And so as an invitee or a guest of the store, they need to make it safe for you. They're not required to catch the snow as it falls and keep it off the ground.
Sure.
And keep you safe.
That's a clear case of what's not reasonable. So interestingly, there are a few things that are known hazards. Some of them I question, and let's just run them by you. So uneven floor surfaces. I understand that it could be something that caused someone to stumble. If someone knows about that, if you're a store owner or an employer, you have to fix that floor if it's uneven, because if you don't, someone is likely to sue you if they fall. Is that legitimate?
Well, that's going to depend on the circumstances.
Okay, circumstances.
So
okay.
Let's just say, for example, what comes to my mind is an old log cabin store that's like from the 1800s, and they have the wood planks. You're going in, you know what you're going into. Is it reasonable to expect that those floors are going to be perfect? And are they supposed to be perfect? And what is it that you're being invited into? If it's like Sturbridge Village, I think, is that a place where they might have old homes and stuff
Yes.
that you're walking through? They're recreating what it was. That's what it is. That's expected. But if it's a modern, bright store that was either just built or is fairly new, and it has a floor that over time something has happened to, maybe it's a cement store that got a crack in it, you know it's got a crack, you know people are going to walk through that, they could be hurt by walking through that, then you have a duty to repair that.
Okay, so you are making some distinctions about what's reasonable, and I think that that's important. So when they talk about unsuitable floor coverings, yes, we can get that. Wet and slippery floors, you've addressed that. Changes in levels, I guess that makes sense too. Trailing cables, clearly, I would think that if you see that, you should do something about it fairly quickly. Poor lighting. Now, what's considered, seems like that could be highly subjective.
Well,
no?
It can be, but it can be pretty clear cut
Okay.
too. I'm thinking of a case I've had in the past where the lighting in a particular place wasn't suitable for where you were asking people to walk from one side of the restaurant to another, and there's no reason for it not to have been. And so, a clear example could be where there's lighting fixtures and the light bulbs are out and they haven't been replaced.
Okay.
Well, yeah, you got to replace those. A lot of times you see that in sort of residential type of cases where the front porch light's out, or if it's a multi-family home and this common area stairway lights are out. Where there should be lights or there are lights and they're not fixed or replaced, those are pretty clear-cut cases of poor lighting.
Makes sense. So if an employer has someone who is responsible for maintenance or risk assessment for these kinds of things, and someone falls, is that employer in a better or a worse situation? Because, well, you play that out.
Okay, so here's the thing. When you use the word employer, you're making it seem like the person who fell may be an employee, which is somewhat of a different case because we're talking workers' compensation then.
Okay.
And is that third party responsible for it, which might be a third party case, not really the topic for today. But
it's a factor.
It is, but let's talk about a store that has a contractor And here's an example comes to my mind of cases I've had where a store or shopping area, mall, whatever, outdoor, strip mall, has a contractor for removing snow and ice. Now, the owner of the shopping center may be responsible to you for falling on the snow and ice that hadn't been treated, but they may have a claim against the person they contracted with to remove the snow and ice. And you, if you know about them, they're raised and that may be able to make a direct claim against that person because they owe the duty to you as well as to whom they were hired by to do a good job. So yes, as a store owner or a shopping mall owner or a strip mall owner, if I hired a contractor to remove snow and ice, I want something from them to show that they have liability insurance in case they don't do a good job, so I can either recover from them what might be recovered from me, or I can pass the case along to them and say, hey, you're responsible. I was sued, I'm bringing you in, and I'm tendering the coverage, so to speak, to you to defend this case.
Okay. How about, and this one is a common situation where people who are in assisted living or nursing homes, there's a vulnerable population. We know, as I cited earlier, that people who are over 60 or whatever certainly are more likely to have a problem, never mind with the slip and fall, but also the consequences and the fallout from the injury. Those places have people who are dealing with maintenance. They also have regular reporting to make sure that things are checked and balanced and they've done what they should do, yet it happens. How do those cases play out when there's slip and falls, because it does happen and it may or may not be negligence?
So, shopping, grocery stores, supermarkets usually have a checklist too of all the times they've gone out to sweep and checked and do whatever it is that they do to try to maintain the place. There can still be negligence, even if you have a process in place. If your process fails to discover something that should have been discovered and doesn't deal with it. So if you slip and fall in a nursing home and there's something on the floor that somebody who works there left there and didn't pick up and knew it was there, there can still be negligence even though they have a process in place. But if their process is pretty good and it's followed everything and that your slip and fall isn't a result of something that they did wrong, there may not be a claim against them because sometimes people just fall. But for the most part, to have a claim, it's something that they didn't do that they were supposed to do, or a defect that they didn't fix.
Okay. And about this overall process, so once someone has called you, they either can or can't be with you in your office to go through the listing of what happened when. You already know that in most cases, somewhere an insurance company is going to try to reach out and say, we'll take care of that. Address that topic, and if you will, and what someone should do if they are the victim or they're the person who's injured.
Yeah, so the insurance company may reach out and say, we're going to help you, we'll take care of this. We want to send you some medical releases so we can get your medical records. We want a statement from you to find out exactly what happened. And in the meantime, they're out looking at the scene trying to find all the evidence they can to prove that they weren't negligent or weren't at fault so they don't have to pay you anything. So I would say, thank you for calling. I appreciate your concern. I'll have my attorney contact you.
So you advise that they not fill out a form, not discuss what happened, when it happened, or what state of medical attention's being given to them. Discuss nothing?
Yeah, that's what I would suggest. If you're at the store where you fell or something and they want you to fill out a form with your name and address and contact information, yeah, I would fill that out because it's evidence that it was you were there, this is what happened. But I wouldn't give any information to an insurance company on what my treatment is, what happened, that they can get directly from your attorney.
Okay, and so if there is a case, you're going to be dealing with the insurance company, hopefully negotiating so that you don't have to go through a long and protracted, annoying, haggling, whatever.
We can talk about the litigation process another time.
Because it's a long one.
It's a long one.
Address one topic, if you would, though. Often when you're involved in these situations, how do you address the fact that an insurance company might, or someone who is trying to say that it's not my fault, no mea culpa, that you, the injured person, had a pre-existing condition, so it really wasn't that incident caused it, it might have exacerbated.
Right. Pre-existing conditions are something that will affect what the damages are. They actually can make you more susceptible to a greater injury than might have otherwise happened if you didn't have that pre-existing condition. For example, if you recently had surgery on your knee and your knee is perfectly fine, it had nothing to do with the reason you fell, but you fell and all that surgical repair is ruined because it was still in the process of being healed. The fact that you fell due to no fault of your own and had nothing to do with your knee injury might make you susceptible to more damages. So you have to take a look at the situation and the circumstance. Of course, in that situation, the insurance company is going to say, well, you fell because your knee, and it had nothing to do with the fact that there was no lighting, there was a defect in the floor that you fell on, or there was a banana that had been sitting there for 6 hours.
Exactly. So you're going to have to haggle with, discuss, and prove that it wasn't that person's knee that caused that.
Right.
And you're able to do that, or at least discuss it and negotiate what some of the alternatives might be to settling that, correct?
Correct. Yes, and it goes into the assessment of is there comparative liability? Did you have a defect that you should have seen, that you should have been able to avoid? And it goes into what are the extent of the damages.
Okay, and so while I'm not expecting to be slipping on some wet surface or olive oil that slipped in a grocery store, but if I, in my chosen line of work, say I was involved in construction, we're not talking about workers' compensation, okay, which is yet another topic that we could address, but hazards of the trade, does that keep you from having a viable case because you should have known that there is broken concrete near that work site or whatever? How does that change the nature of the case?
There are some defenses that could come in, assumption of the risk. You knew there was a danger and you took the risk anyway, or comparative negligence because you knew there was a defect and you could have avoided it. Did you contribute more to the injury than the defect that was already there? These are all different types of defenses that might be raised if there was a work site injury where you're walking through the work sites, things like that.
And that clearly would be workers' compensation, which is...
Not if you're working there, but you could have been an invited guest.
You could have been an invited guest, and then it would be personal injury?
Perhaps.
Thank you so much for tuning in to this discussion on personal injuries and slips and falls. Stay safe, stay tuned to The Law Matters. It matters to you.